Alex here with a video on high conflict child custody. This is the third quick video. If you go back 2 videos, you'll see where I explain what I'm doing here. I'm covering some terms really quickly that people don't understand what they are, and I'm seeing it trip people up. So in this one, I'm covering post-judgment discovery, and it blows up in people's faces in Nevada all the time. Here's why. There's a special rule in the Nevada Rules of Civil Procedure. It adds a hurdle to you if you're trying to do any kind of discovery in a family case after your trial's over or after you've settled. A lot of people settle their case, and those people don't ever have a trial. So, for example, you'll file your petition or your complaint for divorce. You'll meet with mediators. You'll go to court, and you'll just settle. That's it. Your case is closed. You've lost your chance for discovery, for formal discovery. For the other people who actually did go to battle, who did go to trial, they probably remember going through a discovery phase. That's their formal discovery phase. They've gone through it. Their case is closed. A lot of stuff in child custody cases happens after the trial or after the settlement. It's called post-judgment proceedings. People try to modify custody all the time. People try to modify child support all the time. If you want to do discovery after you're settled or after your trial is closed, you have to follow the extra rule. There's an extra rule in the Rules of Civil Procedure. I think it's NRCP 16.1. I may be wrong. I'll check it later and I'll post it in the comments if I didn't get it right. And it explains that you cannot do discovery unless you ask the court for permission. Some people try and do that without asking the court for permission. They get sanctions. Their stuff gets thrown out. The judge gets pissed off because it can look like you're just trying to harass your ex. So follow that rule and ask for permission to reopen discovery, and you'll usually have to say specifically what you want to do discovery on and why. Now, this doesn't mean that you can file a motion to modify custody and go to court and say, I couldn't figure these things out because I wasn't allowed to do post-judgment discovery, or because I would have had to ask for permission. That's not going to fly. If you have to find an issue out, you can't just say it was too hard because of that extra rule. You have to actually do it. You have to ask the court to allow you to discover whatever that particular issue is. In my case, I needed to get some documents from Child Protective Services. So if I would have gone to court and said, oh, that rule's too hard, just believe my words, I mean, I would have lost. I had to file my motion to modify custody, and then I had to also file my motion to reopen discovery and say, here's what I need. I need to send subpoena ducas tecums to Child Protective Services. Here's why I need to do it. And then, of course, it was granted. Anyway, I'm going to go ahead and end this video. It's supposed to be really quick. The point of this video is check in your state, because it may be the same thing. It may not just be a Nevada thing. If your case is closed, if you've settled your case, and you need to do discovery, check your rules and see if you have to ask permission before you start doing it. Before you start subpoenaing people, and before you start, if you need to send any requests for admissions, interrogatories, all that other stuff that I think I mentioned in my discovery video. If you need to do any of that stuff, you need to ask for permission in Nevada. Check and see if your state requires you to do the same thing. And if you have to do it, you just have to bite the bullet and do it. So with that, I'm going to go ahead and end this video.